Hi, I'm Greg Dell, and today I'm here with attorney Cesar Gavidia. Hi, Cesar.
Hi, Greg.
And we want to talk about private disability benefit denials. Cesar, obviously, if somebody has a private disability insurance claim, it's significantly different than a ERISA-governed disability insurance claim, and a lot of people don't really know the difference between those two. So just for purposes of this video, the ERISA policies are usually the ones provided by the employer and they're subject to the ERISA regulations, whereas the private disability claims are the ones where you bought your policy on your own from a insurance agent or directly from an insurance company, or you got your policy through a group association like a medical association or an accountant association or maybe a firefighters association, something like that where it's likely not subject to ERISA. So this video, I just want to discuss about what are the options for somebody if their private disability claim has been denied. And from the get-go, when somebody calls you at first and they say, look, my benefits have been denied, how can you help me?
Sure. Well, Greg, as you stated, we're dealing in this realm of long-term disability insurance. So we've got these ERISA-governed claims, as you noted, they're the employer-provided plans for the most part. And then you've got these individual disability policies, which are these policies that are obtained through either an insurance agent or somehow it's obtained independently by this insured, by the person. And interestingly, when these claims are denied or challenged, the options for many of these disability carriers aren't too different, except that with the ERISA claims, you're required to go through this administrative appeals process, and with the individual policies and the individual claims, it's usually an option. In other words, they usually give you an option to submit further information supporting your disability claim or, exercise an administrative appeal or send in some sort of letter or further medical records to support, your disability claim. So that's certainly one of the options available. Another one of the options available, certainly if you find yourself denied on an individual disability claim under an individual disability policy, is to sue the insurance company or pursue legal action against the insurance company in court. And the reason you're able to do that in these individual claims is because this is a contract between you and the insurance company. Okay, it's not like these ERISA claims or these group policies where you have a group policy that's usually held by the employer, and then the employer or the insurance company issues certificates out to the individuals, which is how they become basically insured under the policies.
Right.
In these individual policies, it's a direct relationship with the insurance company and the insured.
And that contract has the specific policy language saying how disability is defined, how long the elimination period is, what the monthly benefit's going to be, residual versus partial disability.
Right.
Lifetime versus non-lifetime, cost of living increase, all of those things.
Exactly. And usually, with those individual policies, people go through, several, they have to go through basically evaluations to obtain them in the first place. Individual evaluations, medical evaluations, financial evaluations, just to qualify them for the benefits on those policies.
So you've handled hundreds, if not thousands, of individual disability claims, also known as private disability claims.
Yep.
When would be somebody calls you and says, Cesar, I'm a physician, I've been paid for 5 or 6 years, or I was never paid at all, and they've denied my claim. What's your first plan of attack that a potential, that a claimant should expect if they were going to hire you?
Right. Well, usually I try to follow the same plan of attack that I follow with an ERISA case. Why? Because in these ERISA cases, I feel like you're held to a higher standard as far as how you approach them. You have to, basically do your due diligence in obtaining all of the claim file documentation from the insurance company, go about gathering all the medical records, medical data that you can obtain to support your client's disability claim. And really, irrespective of what my plan is going to be as far as whether I issue a demand, file another appeal with this individual carrier, or sue them, I have to have all this information in my hands. I have to know my case inside and out.
Okay,
so that's usually one of the first things I do.
So you want to gather all the information.
Exactly.
And then one of the barriers we run into sometimes is that some of the companies will release information to us, like a claim file and everything that they have, and others will say, we're not giving you anything.
Right. So that's one of the drawbacks of an individual claim, is that although we can ask for all this documentation, all this information directly directly from the carrier. Unlike an ERISA claim where they have to provide it and they have certain, the regulations require that they provide it within a certain time frame. And the individual claims, they could say, we're not going to give you anything. It's work product. If you want it, sue us and subpoena the information.
Right, and some of the companies will say that and some won't. But one of the things about whether or not, and we always brainstorm these ideas with the clients, should we sue them? Should we do an appeal? Should we call them and see if maybe we can get in a position to work something out with them because of the long-term relationship we've had going back and forth with these companies? Is sometimes the claimant comes to us and the file is really lacking in medical support, whereas we think, we can avoid a lawsuit for you and possibly win this claim because you're missing a few key points of medical information that we think would make your claim better.
Yep.
And then the other thing about that is that even if we think the claim can get better, we'll want to get that additional information because we'll want to be able to use that information later on in litigation.
Right.
So, can you give an example of a situation where you've done that, where you've been able to get additional medical support and then use that to the claimant's advantage?
Yeah, actually, I'm dealing with a similar situation now where I'm representing a CPA where not all of the medical information that the insurance company was seeking out was actually obtained. They gave them a certain time frame to provide the information. The doctor's offices, for whatever reason, didn't provide it, and the insurance company declined further liability, declined the claim, and terminated the benefits. This is an individual who was being paid for some time already. So we're in the process of gathering this missing information, reviewing the missing information, and providing it to the insurance carrier because the insured also has obligations of complying with their proof of loss, submitting the information that they're requesting in order for the insurance company to be able to determine that they actually have liability.
So one of the things that I find in most of my cases, I may end up saying, hey, I know you've seen these doctors for whatever your condition is, but I would like you to see a different doctor as well to bring in another opinion. Or I may want to have someone do a functional capacity exam. Or I may want to have them do an independent medical exam to try to bring in additional medical support that can make the claim stronger. And a lot of the claimants don't look at this because the way we look at claims is from a forensic standpoint, and the claimant and the doctors are looking at it trying to get the claimant better or manage their pain. Right. So that's a big difference that we as lawyers, when we look at your file, we're looking at a forensic standpoint. The disability carrier is looking at a forensic standpoint, and you as the claimant are looking at it the way you should, which is how am I going to get treated and get better? And unfortunately, the two are not symbiotic, and that ends up being to the disadvantage of the claimant. So that's when I really think you need to have legal support in order to really put your claim over the top and get you into a position to get paid. So, this is, we've talked about, hey, here are some scenarios maybe if we have to avoid a lawsuit. Now where really a big chunk of your time is spent as a litigator and trial attorney is, what's this process like once you say, we've exhausted everything we can do to try to get you paid, now we had to file a lawsuit.
Yeah.
What's that like?
So, you mentioned, just from our experience in the context that we've developed over the long time that we've actually been handling these disability claims, usually with most of these disability carriers, we've successfully resolved a lot of these problems or issues without having to resort to a lawsuit. So resorting to a lawsuit is, for us, in most instances, one of these last resort type of situations. In other words, we know the insurance company, regardless of what we provide to them, regardless of what we do, they're just going to say, no, right. We're not going to pay any benefits. At that point, we consider them in breach and we sue them. And once you get to that stage, it's, we're within the judicial system. The courts often set our trial period, our discovery periods. They basically dictate the time frame. And depending on the court, and federal court, usually they stick very strictly to the time frames. Very rarely can you deviate from what the judge sets. He says, okay, you have trial 1 year from now. Well, you're going to trial 1 year from now, and you better get everything you need done, all your discovery done throughout that period. What basically an insured can expect during that time, they're going to be deposed. We're going to be deposing the insurance company's representatives. We're going to be hiring experts. We're going to be aggressively handling their claims, zealously advocating for them, and trying to get those benefits they're due.
And the amount of time that can be involved usually from the time you file a lawsuit until a trial, what do you usually see that is on average?
Well, right now, most cases are being set about a year out. I have a case just recently that I filed in the Southern District here in Florida in federal court that we have a trial date just set 7 months from now. This is what we describe as the rocket dockets. I mean, the judge wants discovery finished by the end of August, and we just filed the case last month. So you got to work quickly. You don't always have ideal timeframes to do the work you need to do, but you just have to do it.
And from your cases all over the country, I know you have multiple cases in California. What's the time frame looking like out there in terms of a time frame?
Well, California, like Florida, like New York, like a lot of these areas or states, Texas, right, that there tends to be higher levels of litigation. The courts seem to be more backed up with various types of litigation, not only insurance claims, but all types of claims. You got to remember, these federal judges aren't just presiding over civil cases. They're presiding over criminal cases. They're prosecuting these terrorists. They're very, very busy. So the dockets tend to get very full. You tend to see cases that sometimes don't have a trial date set for a year and a half. So it just really depends. That's what, California, I'd say, is very similar to Florida, New York, and Texas, where we're seeing about a year to a year and a half set.
So just to talk about from our trial experience, and we've tried a few cases together, the expectations of once you go through all of this discovery, which I think is sometimes helpful, sometimes not, but basically you're doing all of the discovery, the depositions, and requesting documents to try to lock down people's opinions. That's basically what it is, so that when you get to trial, there's no surprises. But you and I both know at the end of the day it's going to come up to what a jury has to say, because this is a private disability claim. You're going to get a jury trial. On ERISA, you're never getting a jury trial. So you're going to have either 6 people or 12 people. It depends on what jurisdiction, what state we're in when we're trying the case. And jurors can be fickle. There's no guarantee whatsoever as to whether or not the jurors ultimately are going to have to determine, are you unable to do the duties of your occupation, or are you unable to do the duties of any occupation, depending upon what that definition of disability is. And there's no level of certainty once you get to the trial. So I think that's a big thing that not everybody, a lot of people watch these shows on TV and see the judges and things like that, and we've all seen the movies with the juries, and we've all seen the big cases that are out there, from the recent criminal cases out there all the way back to the O.J. Simpson days, and everybody has an opinion. And at the end of the day, with your disability case, as good as we are as lawyers, as good as their lawyers may be, it's the jury that ultimately makes the decision in most of these cases.
Right.
But you have the cases too where there's a lot of legal issues where it may not make it to a jury.
That's right. So, of course, the insurance company and their defense attorneys, and they usually hire, some of the best defense attorneys who are specialized just like we are, or very experienced at least, just like we are in this area of disability insurance, to defend them. I mean, it wouldn't make sense that they would hire anybody unfamiliar with this type of litigation and this type of insurance to defend them. So they do hire law firms that know very well what the state of the law is with regards to disability insurance. So we see, insurance company lawyers attempt to try to what we call dismiss cases after they're filed. They try to file motions to dismiss. They'll file motions for summary judgment, which essentially basically means that there's no issue of a fact here. There's just an issue of law for the judge to decide. This isn't an issue to go to the jury, and they try to get the case dismissed that way. In most cases, we succeed. I mean, when it comes to summary judgment, because there usually always tends to be an issue of fact somewhere in your case, whether it's there's a difference of opinion by their doctors and the claimant's doctors. We're there because we obviously aren't agreeing on the facts. So there's usually that genuine issue of material fact to get us through that type of issue, summary judgment issue. But yeah, I mean, they'll try everything and anything to try to get these cases dismissed without having to go to the jury, because just as you mentioned, our level of uncertainty, or the level of uncertainty that comes from placing your case in the hands of a jury, the insurance company goes through those same, and their lawyers go through those same feelings and same emotions, and until that jury comes back with the decision, nobody knows what they're going to do.
Right. So, I mean, the reason we're talking about that is so that there's a lot of claimants who watch our videos because they may have another lawyer, or they want to know what to expect because their claim has just been denied. So we wanted to give them that perspective. I mean, I personally love going to the trials and representing, advocating for the claimant and letting their position be known to the jury, and then going up against these insurance companies. Because when we decide to take on a case, and we usually do them only on a contingency basis, so we're not getting paid unless we win, we got to believe in the case.
Yeah.
I mean, if we don't believe in the case and we don't think you're going to win, we're not going to take your case. But all too often I see these other lawyers who might be a criminal lawyer or a personal injury lawyer or some kind of civil divorce lawyer, and they try to jump into a disability case, and they're really they don't really know what they're doing when it comes time to present a disability insurance claim, and I've seen them get eaten up by the defense attorney and by the insurance company. So you really want to investigate your lawyer when you go to hire one. Do a thorough, ask a lot of questions, ask them the trials they've been in, ask them how many depositions they've taken, ask them what they know about all of these different insurance companies, how many claims they've handled with the insurance companies, because I don't think there's maybe more than a handful of lawyers in the entire country who have more experience than us, or quite possibly no one has handled as many cases as we have against each of the other companies. So whatever stage your claim's at, give us a call. We'll be happy to provide you with a free consultation, and we'll be able to let you know right away, based upon the information you provide us, which is usually within 24 hours, whether or not we think we can help you with your claim.